Today we're going to review the management agreement. I have a sample management agreement that you can reference. Obviously, you can pause this video at any time while I'm showing you the management agreement. You can review the specific language. And I've even gone ahead and highlighted some clauses that I think are of particular importance. I'll give you the usual disclaimer that you're going to want to check with a legal professional on any management agreement that you put together in advance to make sure that the language doesn't supersede that of state and local law. So starting off here, we'll just go kind of right through the document. And again, while you're watching this video, just pause it and you can view specific sections of the management agreement as we go through it. That top here, pretty boilerplate. We've just got the language about the day that this agreement is being entered into. We've got the parties who are entering into the agreement. Right down here, we've got the property addresses. So list all the addresses of the properties that are being managed. Hopefully there's a bunch. Full count of units and also any additional structures, right? If there's a shed that you're going to be responsible for, if there's a detached garage, things like that. Term of the agreement in and of itself is pretty standard, but below here, make sure you check with an attorney on this. Upon expiration, the agreement will essentially auto-renew for the same period of time. I know in some areas that's not permitted. The reality is a management agreement is all about trust. And I had many relationships with clients that lasted, over a decade, and we never re-signed a management agreement once during that time. So I would notify them of changes, to the agreement, but we never did a re-sign once because it's all about trust. They're trusting you to manage their money. They're trusting you to manage their property. And the agreement is kind of secondary to that. Of course, it's a critical document, but my point is it's all about trust. To that point, also, if you ever feel like they're not trusting you with any of that, you're really going to want to sit down with them and make sure you clear the air, because as soon as you lose trust in one of these relationships, it's not often regained, and management becomes much more difficult to the point where you're probably not going to want to do it anymore if you lose the trust with the client. Here's an important snippet that I've highlighted. Manager does not intend to displace the owner's duty to maintain, manage, operate, rent, or lease the property, but to aid and assist. That's a really important distinction, right? As the manager, I'm hired to aid and assist. I'm not hired to do everything. I'm not hired to become the owner of the property. I'm hired to help. And that's a really important distinction there. Owner is still responsible for everything at the end of the day, right? You're just hired to help. Collection of the rents, pretty standard. Kind of outlines that you're going to collect the rents, how you're going to collect them, what you're going to do with them. I have on here, manager shall be entitled to collect and keep 100% of the late fees, because the reality is you're the one doing all the hustling to get the rent, right? So you should be entitled to the late fees. Security deposits, you want to have a really good distinction here, where they're going to be held, who's going to be hanging on to them. Some of our clients insisted upon holding on to them. If that's the case, it's fine, but they need to tell me that they're holding it in a separate account and they're not commingling funds. And they need to tell me that it's in an interest-bearing account, because that will be called into question when applicable. Tenants will call that into question as an argument to get their deposit back. So make sure you have that base covered. Repairs on here in this clause, the really important part is the dollar amount, right? So imagine if you had an arrangement with a client where every single expense had to be run by them and approved. That's going to make your job a lot harder. It's going to give you a lot more work. It's going to delay things getting fixed. I put in 500. I would recommend going to 1,000 these days. Basically anything, say $500 or less, you don't need their approval to do. Again, the relationship's about trust, right? Do they trust you? Down to emergency repairs, you definitely want to have language around emergencies, right? I'm not pausing in the middle of a, smoke, fire, water, electrical issue to run it by the owner at 2 o'clock in the morning. I'm going to stop the issue from occurring. I'm going to stop the damage from occurring to their property. I'm going to stop the immediate hazard that it poses to the safety and well-being of the tenants. To that end, if I have to pay somebody to do it, I'm not going to pause and ask the owner if it's okay. That's going to really undermine your ability to do your job if you had to do that. So make sure you have language in there. You've got language around the leasing process here. Taxes and mortgages and operating costs basically states that the owner is still responsible for that stuff, and I, as a manager, never paid their taxes. I know a lot of managers did, or some managers did. I don't like that. Managers paid the utilities, like the water bill. I say keep the owner responsible for that, keep that in their name, have them responsible for doing it. Leasing, again, that's going to just indicate that you're going to make your best effort to keep their property rented. Execution of leases, tenant communication, this is important. You don't want to get into a mom and dad situation, right? What do I mean by that? I mean, the tenant doesn't like what you say because you said no, and because you're fair and reasonable. So they defer to the owner, and then they badmouth you, and they tell the owner how awful you are, how unattentive you are. They're just doing the mom and dad thing. They don't like what mom said, so they're going to dad. I want to make sure the owner knows that all communications are going through me. And if an owner insists upon having communications go through them, that illustrates a lack of trust. And now we have a bigger problem in the relationship. Here's the insurance section there. You're going to want to make sure that the owner has adequate insurance on the property at all times. This $300,000 limit, that's a little low. We're probably up to $1 million now, but check with an insurance professional on that before having that sort of memorialized in your management agreement. Security deposits, access authorization, hazard substances, pretty standard. National Grid, this is the leave on for landlord that your utility company may or may not offer. Great if they do. Definitely have the language in there stating that the owner will enroll in leave on for landlord. It'll eliminate a lot of cold weather emergencies. Permits, owner should still be responsible for ensuring all permits are in place when applicable. I had language in here for periodic inspections. I said twice a year I'm going to go through, even if everything's great. I'm going to go through twice a year and do a property inspection for the owner. You can or can't put that in there. It's up to you, what you're comfortable with. Then you've got some other standard language, owner's liabilities, record keeping, monthly accounting. What reports are you going to be responsible for getting to the owner? Balance sheet, P&L, things like that. Record retention, how long are you going to retain records for? I can't tell you how often somebody would come to me 6 months to a year later asking for information, oftentimes what I already gave them. So I started charging for it. I said basically 45-day period. After that, you've presumably been given everything. I'm going to charge you by the hour to give it to you. I think your time is worth it. Operating account, it's just listing, the operating funds, where you're going to be holding them, how you're going to be holding them. Security deposit language. Then you've got cooperation. You've got compensation on here, how you're going to be compensated, when you're going to be paid, how much you're going to be paid. I even had some language in there about lease renewals. You'll be paid X number of dollars every time you renew a lease. There's also language in there about, I actually added it in here about invoiced amounts of $5,000 or more. The manager shall be entitled to X amount, X percent of that. So basically think about like capital improvements, right? If you're doing like a $100,000 roofing job and you're overseeing that project, well, you should be paid for your time in overseeing that project, coordinating with the tenants, coordinating with the vendors, presumably getting the bids, making sure the vendor's doing their job, inspecting it when they're finished, making sure they get paid, things like that. You should be paid for that. So I was paid $5,000 on jobs $5,000 or greater. We were given 5% of the cost. You can adjust that as you see fit. Sale of the property. This is going to happen a lot. You're going to have owners hire you to stabilize their property so then they can turn around and sell it. Well, you should be entitled to money from that. You're the one who stabilized the property. You're the one who made it look beautiful again and very appealing to a buyer. And here's another example. Many times this will happen where a tenant buys the property they live in. Well, if I place the tenant, I place the buyer. I should be entitled to some money for doing that. So I learned this one the hard way. After about the second time, an owner hired us to do all the heavy lifting and fix their property, and then they turned around and hired somebody else to sell it. I put this clause in there, and I would not sign on new people unless they agreed to it. Termination without cause, 60-day notice. Otherwise, what's the point, right? So 60-day notice, I think, is reasonable for termination without cause. I don't like 30 days. Then it essentially becomes a 30-day agreement. In the event that 50% or more of the property is vacant for a period of 90 days or more, we like to have this clause in here. Quite often an owner will say, I know you think this apartment is worth $1,500 a month or $2,000 a month. Let's try to get 2,500. Okay, well then we might not fill it, right? So then therefore I shouldn't be responsible for that not filling in 30 days or 60 days even. So that's why I extended it out to 90 days. Hopefully within that period of time, the owner has come to their senses. They've seen some of the showing metrics that I provided them. They've seen, we've had 70 showings here. We've had no applications. That data tells me that they don't think it's worth the money. So 90 days of 50% or more of the property being vacant, they can cancel the agreement. I think that's reasonable. You've got standard language, final accounting, authority, record retention. How long are you going to retain records for? Cost to provide said records after that period of time. Power of attorney, amendments, assignment, governing law. This is all sort of standard boilerplate language. And then, of course, at the end, you've got the signature space here. But again, take a look at this video. You can pause it at any time. You can extract any of this language if you think it's beneficial. If you have a current management agreement, take a look at this agreement. Perhaps you'll find some sections here that you really like, and obviously feel free to modify as you see fit. I hope you found this video helpful. And of course, feel free to reach out if you have any specific questions that I can help with.